Okay, cool. Tēnā koutou te komiti. Today I'm here to speak on behalf of Ngāti Maru, ki taranaki in opposition to the Treaty Principles Bill. The bill fundamentally undermines the Tiriti o Waitangi, our treaty settlement and the constitutional relationship between the Crown and Māori. In the perspective of Ngāti Maru, it is a direct attack on the foundations of our legal political framework, one that will be devastating and have devastating consequences for Māori and for Aotearoa as a whole. Ngāti Maru holds grave concerns about the intent, process and impact of this bill. Today I will address several key issues. First, I will outline the historical suppression of Māori and its ongoing effects to provide context of why the bill is so damaging. Secondly, I will explain how the bill fails to uphold the principles of Te Tiriti o Waitangi and why its redefinition is legally, morally and constitutionally flawed. Third, I will highlight the government's failure to consult with Māori and the development of this legislation, which in itself constitutes as a breach of the Tiriti. Finally, I'll discuss the long-term consequences of this bill and how it undermines the treaty settlement process, weakening the relationship between Māori and the Crown, and ultimately foster greater division rather than unity. The historical context and suppression of Māori and its ongoing impacts. Before we discuss the specifics of this bill, it's critical to acknowledge the historical suppression of Māori and how it constitutes to impact on our people today. Te Tiriti o Waitangi, as we all know, was signed in 1840, with the understanding that it will create a relationship of partnership, protection and participation between Māori and the Crown. However, instead of honouring this agreement, the Crown imposed over 135 years of suppression through war, land confiscations, forced policies and legal discriminations. These injustices were not accidental, they were deliberately calculated actions that designed to strip Māori of our whenua, our reo and our tino rangatiratanga. For Ngāti Maru, like many iwi, the impact of this history is deeply personal. Our people lost vast areas of lands through confiscation and unfair land dealings. Our tupuna were alienated from their resources, their language and their cultural identity. Generations of our whānau have suffered the consequences through poverty, incarceration, health inequities, all stemming from the systematic marginalisation of Māori. While the treaty settlement process has provided a mechanism to begin addressing these past injustices, we cannot ignore the reality. Settlements are not full compensation for what was taken, and they are based on the Crown's recognition on treaty principles. If those principles undermine, then so too is the entire basis for settlement agreements. The bill's attempt to redefine the principles of the Tiriti in a way that disregards decades of legal and judicial interpretation by both the courts and the Waitangi Tribunal. The principles of the Tiriti are not just abstract ideas. They have been developed through case law, extensive legal scholars, and careful examination of the original intent behind the Tiriti. These principles, partnership, active participation, redress, and participation, form the foundation of how the Crown must engage with tangata whenua. Yet this bill seeks to remove these principles and replace them with a narrow, restrictive definition that favours the Crown authority over Māori land, Māori rights. It proposes that only valid treaty principles are those that uphold the Crown's right to govern and provide equal treatment to all citizens. This is a fundamental misinterpretation of Te Tiriti. In Article 1 of Te Tiriti o Waitangi Rangatira gave permission to the Crown to exercise kawanatanga, which is governance over the land. The concept of giving is different from ceding. Our tupuna did not inherently give up the sovereignty established in 1835, he whakas pūtanga o rangatira o Nutarini, but instead gave the Crown proper power to govern their settlers by them. Article 1 acknowledges kawanatanga, but in a way that must be exercised in partnership with Māori. Partnership means co-governance, shared decision-making and genuine consultation. This bill removes reference to partnership, making it clear that Māori are seen as subjects, not as equal partners. Article 2 guarantees Māori tino rangatiratanga our absolute sovereignty over our land, taonga and resources. This bill erases that concept. It does not recognise Māori rights to self-determination, kaitiaki and our ability to make decisions on our own affairs. Article 3 promises Māori equal rights and protections under the law. However, this bill uses the rhetoric of equal treatment to justify the removal of targeted mechanisms that address the structural inequality. True equity does not mean treating everyone the same. It means acknowledging historical disadvantage, ensuring that Māori have the tools to overcome it. The courts and the Waitangi Tribunal have been consistently affirmed that Te Tiriti is a living document, one that must be interpreted in good faith and uphold its original intent. This bill does the opposite. It is not an honest attempt to clarify treaty principles. It is an attempt to weaken them and justify the Crown's abilities to ignore its obligations to Māori. In terms of failure to consult, beyond the content of this bill, the way it has been introduced is deeply concerning. The Tiriti establishes a partnership between Māori and the Crown, yet Māori have been shut out of decision-making processes of this bill. The government has failed to engage in genuine consultation with iwi and hapu, instead rushing through legislation that fundamentally alters our rights. This lack of consultation is not just a political issue, it is a direct breach to Te Tiriti, which does not respect the spirit of the foundational document of this country's constitutional partnership between Māori and the Crown. This bill was drafted and introduced without input from iwi, without engagement with the Waitangi Tribunal, without any attempt to uphold the principle of partnership. That is not a sign of good faith government. It is a sign of a government that has already made up its mind, regardless of what Māori think or say. The long-term consequences of this bill, if this bill does become law, it will be one, it will undermine treaty settlement process. If the government can redefine treaty principles whenever it wants, then what guarantees do iwi have that their settlements will be upheld? How can we trust that commitments made with good faith will be honoured in the future? Two, Māori trust in the Crown. This bill sends a clear message that the Crown does not value the treaty obligations. It tells Māori that we are not true partners, but merely another interest group, rather when ignored when inconvenient. Foster greater division in Aotearoa. Rather than strengthening relationship between Māori and the wider public, this bill will inflame tensions, deepen existing inequalities. It provides fuel for anti-Māori. Undermining decades of work towards reconciliation and understanding. To conclude, for all these reasons, Ngāti Māori urges the committee to reject this bill in its entirety. It is not a clarification of the TTT's attempt to, it is instead an attempt to dismantle it. It does not serve the interests of Aotearoa, it serves the interests of the government that refuses to acknowledge its obligations to Māori. If we move forward as a nation, we do so in a way that honours the TTT, not erase it. The treaty was promise of partnership, and that promise must be upheld, not just for Māori, but for the future of all people in Aotearoa. Let's honour the treaty and move forward together. Tēnā tātou, that's my written submission, or my oral submission.
Thank you, Dion. Sam, there's a minute and a half left that we can go.
I can see that, Mr. Chair, so thank you very much for that. So just quickly, tēnā koe huana. Listen, Dion would have covered in terms of the issues that the real concerns that we have around our treaty settlement, which is the ink is still yet to dry on our settlement. We're the last of the ATB and Taranaki. Then on top of that, we were down in Parliament just recently for the Maunga settlement. So in terms of the partnership, that is part of that process. We have some real concerns that this bill proceeds any further. So that's really the big statement from Ngāti Maru. But yesterday at Te Matatini and the Pōiri, there was a statement made that Te Matatini is the opportunity for all of us here in Aotearoa, particularly here in Ngāmotu, to be Māori, to experience those things that make us Māori, in terms of our values, in terms of our kapahaka and all those things that we hold dearly. So that session, that event will give the chance for us here in Taranaki and the rest of the motu to relive in terms of our values, in terms of what we see as being important as being Māori. So what this bill will actually do will actually diminish and, well, actually have a big effect on our rights as Māori. So we're going to enjoy this week, and then we're going to come back at you again. Kia ora. Tēnā koe huana.
Hi, I wasn't supposed to arrive, but I have arrived. So basically, Sam got yeeted off the internet by his router. So I've been asked to step in the meantime. So what did you think of that submission, Nick? Oh, you're on mute.
That's better. There we go. I thought it was a really interesting submission. There was a lot of information there about the history of Te Tiriti and how Te Tiriti got formed and how that impacted on that particular iwi. And I remember when that iwi came down to Wellington to have their settlement bill go through. So I think this bill will have a significant impact on that iwi, and you heard that just from the last submitter there. So yeah, I think that's really quite a personal submission from this iwi around, don't mess with the process because it's doing good things for that particular iwi. And I think that's really quite them speaking, from the heart, really. And I think that's really it's really important that we hear from iwi that have got really positive results from the process. And so yeah, it's good to hear that.
And Laura, thanks for jumping in when I sent you that urgent text message. My Ethernet cable port bumped me off and I had to reboot the computer for the router to give me a new DHCP IP address. Yeah. So thanks for doing that, because I might feel like, oh my God, I can't get there. What the hell's going on? What? And I'm looking at the back screen that's over there, and it's playing perfectly. And it was just like, what the hell happened? So it's just like, Laura, jump in! Shit's happening! And clearly, as we know, that is exactly what happened here. Okay, Nick, thanks for joining us. Laura, thanks for jumping in to save my butt, because I knew Stacey wasn't there to save my butt. And we'll get over for the next hour for the urgent debate of the resignation of
Thanks for watching. Make sure you're subscribed to our Facebook, YouTube, Twitch, Instagram, TikTok, News Scout, the Order Paper Podcast. YouTube, Twitch, Instagram, TikTok.